allow me to take this opportunity to thank Senior for his time, for his remarks. I think one of the things you learn as he's giving us this particular platform to just talk is it's a lot like litigation. A lot like litigation. It's a very dicey situation, especially if you've read The Devil's Advocate. So it's a situation whereby you want to look like you're willing to be in the deal, but you're not too needy and too desperate. At the same time, you've done your background research, you're very competent there, and you know you're in the necessary jurisdiction to actually have that. And when you're speaking, one of the things that I picked on was public policy plays a key role. Even using the Djibouti example you gave. Simple thing that we always learn, when you walk into UAE, there are certain freedoms that as women we probably do not enjoy. So there's no way that possibly a woman might be fronted in a particular deal. It's not, in Kenya we would be hashtag something, but that's a public policy there. And you cannot go and put a deal there and front something that is completely contrary to their public policy.
Then you show up in jeans.
And then I show up in jeans without an abaya.
Yes.
So this is on a light note. One of the things I do in my office, because I handle a lot of Somali clients, is on Friday I normally put on an abaya, not the hijab or anything, just the normal Leicester dress. So after they come from the mosque and they want updates, I'm ready with my very huge abaya. And it's again what you're saying. You understand your.
What is abaya? Is it the kaftan?
Yeah, so for those of you who don't know what an abaya is, it's more like a kaftan and a buibui. So it's those big things. So the modern hijabi queen normally puts it on as like a kimono. And I'm just saying this in terms of public policy. At times, understanding your clients is so hard, but we are getting there and we're learning from the best. And the best here is our seniors. So even as we ready our questions, thank you very much, Senior, for taking time. I think all of us have learned an element of where we're going wrong in our transactions, and we are now trying to get better at what we're doing. And I'm sure the questions that you're about to ask will reflect. So today we're going to do it differently. If you have a question, please go right ahead. I will switch the camera to Senior, but please go right ahead and ask anything you feel that is unclear. Okay, so I can hear Senior at the back just screaming to start. So yes.
So, Senior Eric, something comes to my mind that, and also without sounding over enthusiastic about closing a deal. At the negotiating table, and now you are talking big money, what are the do's and don'ts? You know, I'm assuming we're in a meeting, and the figure on top of our head is $200 billion or $20 billion or $2 billion. I don't think these are figures you just get into a room clueless on how you're going to table them, you know, how you're going to package them. So just in a nutshell, what are the do's and don'ts in big money transactions? Negotiating. Yeah, thank you.
Okay. We take another question as well?
Yes, we do.
If there is.
Yes.
Mr. Omwansa, when you get into a deal room, you must be able to read the mood in the deal room. And you must read the mood in the deal room right. You've talked about 200 billion. So everybody first looks at you, because remember, there could be a place for you to exchange undertakings, a place for you to be in charge of that transaction. So if you're seen being fidgety about a transaction of 200 billion and they're saying the 30% is to be wired to your account as a receiving advocate, and you appear fidgety, what does that mean? Everybody immediately calls off saying, hey, wait a minute, this person looks like he's more in need of this money than we are. Yeah. And then also, as part of not appearing overly enthusiastic, let the other parties express their views. Exercise patience. Let them come through and give proposals. Also offer your client an opportunity to give their thoughts, because it is assumed that at that point in time, you'd have had your one-on-one with your client, and so you've agreed on certain positions. In the event that there's a tie, then you may want to come in as a professional, again, expressing your experience, leveraging your knowledge and experience to be able to untie that knot that may be there in terms of the conversation that is at hand. Sometimes also, even though we know that the primary interest in a deal room is to be able to protect our clients' interests, it must never come out as though you are so overtly going in saying, is our way or the highway? There are times when you must learn to know what to give, what to take. You may also be the one to exercise control in that room as to tell them, can we just get to your understanding of what this is to you? So that then, without just dismissing what the counterpart is saying, you want to be able to give them an opportunity to unpack an issue. It could be that you're pushing them on an amount or a timeline, but they're also, like I said earlier, relying on a third party. So a bank has told them, this is the most that we'll be able to get into, and we'll do this transaction with this number of days. It could be a transaction that is pegged on yet another transaction. Now, unless you then call for parties to unpack the reason behind why they're pushing a particular position, then you may miss out on the point. Sometimes they say, when somebody says no, don't focus on the no as the word N-O. You may want to ask yourself, is this person saying no because they've not understood what you're saying, and so therefore they require a bit more of persuasion? Are they saying no because, as a matter of principle, they don't agree with the position that you have taken in relation to a matter? Or are they saying no just for the sake of giving you a no answer? Now, it depends. In resolving that question, it depends on which no then you're responding to. You must know, you must understand the no that has been presented before you. You must understand the difficulty or the hurdle that has been presented before you. There could be information which, if presented to you, you may also be able to persuade your client to say, no, if this is what they're facing on the other side, then we could reconsider our position, even if it means, again, buying time so that you have further consultation, or even if you need better particulars. You tell them, okay, give us that material that you're relying on so that we can be able to interrogate it independently and get back to you. Again, patience. You say, we'll get back to you tomorrow, the day after. Take time so that by the time you come back, it is something that is appropriately and effectively considered.
Alright, so the first question is on
clients who don't pay.
And the second one is on how to phase out brokers who want to frustrate a transaction. Any other person would like to ask a question before we go for this round? We literally have less than 10 minutes before we end the session. Yes, Jonathan, please go right ahead. Or Mr. Kisia.
Good afternoon, Kai, Mr. Bungo. Thanks for organizing this. For me, my question really is, if I heard Mr. Bungo correct, he had said that sometimes a deal that is advised is good to me may not be a good deal to my clients who I'm acting for. So how do you draw a line between counseling your clients, because that is your work, and advocating for them? Because I ask this saying, sometimes maybe me being the lawyer, I can see that the position or the tangent they're taking will end up being problematic, or a legal issue will arise. But I am aware. So do I just lead my clients to the dungeon, or how do you draw a line between the two? Thanks.
Okay, thank you for that. That's actually a very relevant question to all of us.
Yeah. So I take those ones?
Yes.
Okay.
Take this round.
So I think Joyce asked about how do you deal with the difficult clients who expect your soul but is not paying for it. I think what is most important is always to have clarity of thought or clarity of expectations from the word go. We sometimes get a little shy to mention what our fees is supposed to be and even build it into the transaction because we want to secure the transaction. Now, experience and life teaches us that when you allow particularly the big deal movers to go when there's ambiguity, you'll run into a lot of headwind in terms of the expectation that you have as fees. So the idea is from the onset, once you've had a moment to understand what the scope of your engagement is, you have as a primary obligation to agree on your fees. Once you've agreed on your fees, the next thing is on the milestones. At what point would your fees be paid? So that then You don't wait until the transaction is completed. Then you say, oh my God, I wish this person had paid me the money that we had agreed on. Remember, because you have leverage on them at the point when you're still negotiating, everybody would have an interest in having seeing the deal through. So just like in arbitration, where we say an arbitrator will not give you your award before you've finished his fees, you may want to mitigate against that by not insisting on full pay upfront, but then make it milestone based. Because remember, you'll be putting in your time, you'll be putting in your outgoings. As you ask for the outgoings, the clients are normally very enthusiastic at the beginning of a deal to facilitate a deal, ensure that you plugged in terms of what your fees is supposed to be. If you, however, read a red flag that you had agreed that your fees was to be paid maybe 30% at the beginning, and you're now getting into the place where you're now doing documents, exchanging undertakings, and you've not gotten the agreed amount, that straight is a red flag. Now that red flag would require that you put down your foot. You say, no, we cannot proceed, because that transaction must also be treated with the seriousness it deserves. Clients are very, very sly sometimes. If you do not insist or push the question of your fees, it will be convenient for everyone, because who wants money out of their pocket anyway? But if you tell them, on this transaction, we're not moving forward, in fact, it's part of you just developing your structure so that it is not exactly you who is pushing the client for the fees. You tell the client as to how the fees is to be paid. That is a different user department within your organization. It should be your finance department. You must always therefore be very careful not to resist that invitation by making it not an issue between you and the client. It is, however, important to also create flexibility. So if a client tells you, we were supposed to pay you by Friday, we, however, are expecting our drawdowns to happen next week, give us 2-3 days, create necessary and reasonable flexibility with the client, so that you also don't say it's my money or the highway. So it's more a question of balancing. But more importantly, so that you have an ultimate recourse, you must have a fee agreement. Because a fee agreement is a document that forms the security between you and your client even after the transaction. Because there'll be documents that you're supposed to exchange with them. You can hold lien then over those documents, telling them unless your fees is paid, you're not releasing the documents. And clients also know that when you insist that you have your fees paid, they'll not argue much around it. When they go to international law firms, for instance, will it be a conversation that will pay you tomorrow or the day after? Why then should we encourage that sort of practice in our space? An advocate must also emulate in this jurisdiction or any other self-protection mechanisms, because you're in that room doing your job. If it is not paid for and you've not secured it, then you should then get away with putting it within the transaction. Now, you've asked a question about the obligation of brokers. Now, one of the things that I'd said is, as you initiate a transaction, you must sit with your client so that then the obligations are very well defined. Who is doing what in the transaction? More often than not, you'll realize that the broker's obligations fall by the wayside when you get into the deal room. Their obligation normally ends at bringing the parties together. And you then, for purposes of ensuring that they are not also becoming an issue in the transaction, get a clarity of understanding on what your client and the other client had agreed on in terms of how to treat that middle person. If they'd agreed on some form of commission, and it is something that is supported by the law and supported by the transaction itself, then tell the client that for the neatness and the hygienic handling of that transaction, you have a different contract with that middle person, so that then at the end of the end of a transaction, you as the receiving advocate would be able to take responsibility on paying the middle person, because otherwise then they'll remain in the room because their interest is just to secure that which they agreed upon. But remember, by allowing them in the room, they can torpedo the transaction because they have an interest which is they may want to insist on a transaction going through, yet there's a reason, a very valid reason why your client wants to opt out. So good practice is never allow them into the transaction room. Have them introduce the conversation between you and the purchaser or the vendor, as the case may be. But once that is done, allow them to exit so that you as a professional take responsibility of what you're dealing with. Now the last question is on the extent to which you'd want to push a position to a client when the client is insisting on taking one way or the other. Now the general rule ordinarily is that in relation to commercial decisions, the client wields the primary position. It is, however, helpful to share your experience. If it's something about constructing, call it a mall within, say, Kilimani area of Nairobi, and you have within, say, the last 6 months, 1 year, been seeing property reviews, as part of your due diligence, as part of your day-to-day upkeep with the market, then you want to share with them that whereas you want to do a mall may not necessarily do well because we have this mall in this place within the same area is not doing well. It has 30% occupancy. We have another mall that is coming up. The projected occupancy is maybe 40%, So those would be persuasions. But the ultimate decision lies with the client. Where you must put your foot down, however, is when you talk about what I'd called the legality of the deal, so that it will not be forgivable for you to allow your client to walk into a deal knowing all well that that deal has some form of a blemish. On that, even if the client insists on going into the transaction, you must always then document the fact that you gave advice, but the client chose to go in a different direction. Because if you don't do that, then you may expose yourself to, a suit for not doing what you ought to have done professionally to that client. So I think those are the questions that have been raised.
My question is, how do you win back power in a negotiation? So perhaps you can find that you're in a deal where maybe your client had done something that has offended the other parties, but you're still at the negotiation table, or perhaps you as the advocate, maybe as Senior has given us an example, there is a particular way you're supposed to deal with some particular generation. So maybe you are in a hurry with older clients and you can already tell that they're not comfortable with either you as the advocate or a party, and so you pick up the mood in the negotiation table and you can tell that you're already at the lower hand. So how do you win back your power in such a situation? Thank you.
Thank you, Grace. And I think to give a better example, just with what a Senior had said, so situation, and Grace, correct me if I'm wrong, would be you have a Gen Y client and you're possibly a Gen Z lawyer. And I'm just giving an example. Grace, would that be the position? And you're trying now to win back the power in view of even this intergenerational dynamics. Is that the position, Grace?
Yes. Or perhaps maybe, as you said about perhaps a Muslim, having a Muslim client, perhaps you say something that's offensive, or your client says something that's offensive, and you already see the mood in the room is changing. So how do you bring yourself back to a space where you are level with the other party?
Thank you. That's actually a better example. Thank you very much. Any other person who has a question? This perhaps would be our last round, just seeing the time indication, and I had promised Senior, yes, I'd release them at a particular time. So please feel free, because this is the last set of questions before we do the closing remarks and closing of the session. I know we had indicated 5, but in the interest, my Senior who's at the back, do you have any other? Oh, yes. Any other question? I can see he doesn't have any. Okay, so I will take it back to Senior to answer that one question, which is very fundamental to us.
Yes. Thank you very much for that question. You remember I spoke about something called reading the room. When you get into a deal room, you also read the room, and for sure you'll be right that in one or the other instance, you may have said something, or you may have pushed a position that did not sit well with the parties in the deal room. Now, whereas there is no hard and fast way of dealing with that, The convention, I mean, from experience, what we've seen is when people realize that you are, number one, a good and attentive listener, they also tend to take your interventions with the seriousness it deserves. But now, once you've listened and you've gotten into that position where your position probably has not been taken as you thought it would be taken, it is for you now to think through, how do I get the clients to understand that my comment was nothing but objective? You remember I had said at some point that one of the ways of demonstrating that ability is by showing a clear understanding or mastery of the subject at hand. It is at that point where you'll be pushing to see what appropriate examples would you give to get your clients to appreciate that you're insisting on time, not just because it was whimsical, but because from experience you've seen that push things out of hand. You could bring in things like, for instance, tax efficiency. You say, I pushed you on this because you know we are having our tax bill passing next week. So if we don't do this transaction close of business this week, it means the tax position might change fundamentally into the week that we go into. Now, when you give appropriate examples backed with logic and data, and experience, then people would always, forgive you for what would otherwise have appeared to be a hard position. I think the idea is to always just show that you had no skin in the game other than for supporting the clients to be able to get the most appropriate deal out of what has been presented. Now, there are things that you may not be able to deal with in that context. For instance, when we're talking about the dressing, and that a particular section of the people in the deal room did not appreciate the fact that you came in jeans for a deal that you went to close in Dubai or Saudi Arabia for that matter. Sometimes it is helpful to ensure that you have created a light moment out of those sort of things. If you've ever done a deal with Chinese negotiators, they come in and sometimes they come in very hard. They push the positions, but as soon as you're done with the transaction, the conversations for the day, they have gifts at hand to give everybody, and which is another important thing. They'll be coming in to give you small little things that, whatever it is, the human being and the human mind is always comfortable with being appreciated. Yes, at some point, it could be you offering, let's now do coffee. It's been a long day. It's been a long afternoon. Let's have coffee to be able to wash down this. And in that coffee, then you create a light moment. In that light moment, you can be able to see how, the societies vary, that in one society this happens. So just to create a measure of tolerance, which of course would be a long shot, but it's something that we must always attempt not to leave parties feeling a particular way. If it was wrong, you can also, at an appropriate moment, just tell your client that, I think I misread the room. I thought we were doing this transaction in Nairobi. Little did I know that we were going to end up in Saudi Arabia, and in Saudi Arabia, I got in fact, make it light. I got into that room and I was very uncomfortable because I'm the only one. I'll give you an example. I got into a transaction, and it was a very big transaction. So it involved a client from the Muslim faith. So the menu is brought. People are asking for what they want to have. Shock on me. I call the waiter. What is the most favorite thing here? The guy tells me pork chops. I tell them, please bring those pork chops. My own client was wondering, what's wrong with you? But for me, my mind was just in the fact that this is what is celebrated in this restaurant. So you can imagine how uncomfortable that must have been. Of course, ultimately, I found a place of saying, no, it wasn't meant to offend. That was just a slip up on my part. Sorry. And there's absolutely nothing wrong in saying sorry, particularly when it's a mistake that is genuine. In fact, a lot of times, people take it very positively. Just the ability to eat back and coil back and say, on this, I misread the room. Or on this, I misread the circumstances. I've learned my lesson. And people will not push you. they'll leave it beyond. They'll leave it there, and that story will be forgotten. Thank you.